Hello po mga kabayan, ito po si Ate Chenny, isang registered Canadian immigration consultant dito sa Canada at ako po ay magsasalita tungkol sa humanitarian and compassionate grounds. Disclaimer po mga kabayan, kailangang i-check nyo rin ho ang website ng canada.ca on immigration kasi po pabago-bago ang batas ng immigration. Kaya po meron pong nadadagdag at inaalis nila. Kaya po, ngayon po ay April 19, 2023. Yung may mga batas ho ngayon na lagi namang nandyan at yun po ang aking itatalakay sa inyo. Yung humanitarian and compassionate grounds po, ito po ay application na pinaka-last resort na ng ating mga kababayan na nawala ng status or hindi ho sila makapasa sa ibang mga programs ng Canadian immigration. Sino-sino po yung mga yon na pwede siyang mag-apply? Siya po ay foreign national currently living in Canada. They need an exemption from one or more requirements of the Immigration and Refugee Protection Act or regulations in order to apply for permanent residence within Canada. Katulad po ng hindi kayo makapass ng inyong English test or yung inyong edad. Believe humanitarian and compassionate considerations justify granting the exception you need and are not eligible to apply for permanent residence from within Canada in any of these classes: spouse or common law partner, live-in caregiver, caregivers, caring for children or people with high medical needs, protected person and convention refugees, and temporary resident permit holder. So, yun po yung mga pwedeng mag-apply o pwedeng gumamit ng application ng agency. Sino po yung mga hindi pwedeng gumamit ng application na to? Siyempre, yung mga Canadian citizen, permanent residents, yung mga nakasubmit na ng agency but wala pang decision na naibibigay, and have an outstanding refugee claim, and they became a designated foreign national within the last 5 years. So, kung hindi naman ho kayo DFA, after 5 years, then you can apply for agency. Pagka po, normally, yung mga humanitarian and foreign nationals who wish to immigrate to Canada must apply for and obtain a permanent resident visa from abroad. Foreign nationals do not have the right to apply for permanent resident from within Canada if they do not meet the requirements of an in-Canada immigration class or if they otherwise inadmissible. However, Section 825-1 of the 𝐪RPA or Immigration and Refugee Protection Act allows foreign nationals who are inadmissible or who are ineligible to apply in an immigration class to apply for permanent residence or for an exemption from a requirement of the Act based on humanitarian and compassionate considerations. It is an exceptional measure po. It is not simply another means of applying for permanent resident status in Canada. So in order to be considered for an exception from the usual requirement of 𝐪RPA, you must clearly indicate in your application the specific exemption you are requesting, and then provide all details related to your request, including the reasons why you believe an exemption should be granted on agency grounds, and demonstrate that there are sufficient and compelling reasons for you to be granted an exemption, allowing you to apply for permanent residence from within Canada. So, marami pong mga batas na naipasa na o na-desisyonan tungkol sa agency na pwedeng nating gawing basis. Ito po yung unang-una nung nagkaroon tayo ng COVID sa kay Muhammad versus Canada. Justice Ahmed made a statement about COVID-19 frontline workers in the humanitarian and compassionate context. So pwede ho natin gawing reason to. At a time when most people in Canada were staying at home to avoid the spread of COVID-19, frontline workers were risking their own health to provide essential services. This includes those who work tirelessly in long-term care homes that saw frequent COVID outbreaks and many deaths. So, yung mga employment letter on the record states that the applicant has been employed at a certain care society, malaking bagay po iyon to use for the agency. Another is the ordinary operation of the law. 𝐂𝐨𝐽 po versus Canada, where the remark about paying deference to the law and status of Canada suggests a significant misapprehensions of the officer's role in evaluating a S-25-1 application, which is not simply pay deference to the ordinary operation of the law, but to weigh and consider whether agency considerations warrant a flexible and responsive exception thereto. So, ito po sinasabi na yung mga, first and foremost, the raison d'être of the agency exception is to overcome non-compliance or other obstacles posed by immigration rules by offering equitable relief in circumstances that would excite in a reasonable, in a civilized community, a desire to relieve the misfortunes of another. So there were compassionate circumstances here that the applicant submitted, but the officer simply did not address, instead reciting a need to be deferential to the law. So sinasabi yun yung example na pagkakamali ng officer. So sinasabi po nitong batas na to o nitong decision ng court na to na pwede yun. Ang sunod po yung 𝐶𝐵𝐶𝐚𝐵 versus Canada, sikat-sikat na po ito, yung discrimination, where the officer agreed to consider the hardship of 𝐶𝐵𝐶𝐚𝐵 would likely endure as discrimination in Sri Lanka. So yung sinasabi po na that direct evidence is not necessary to establish potential discrimination and related hardships. No. Ang 𝐂𝐨 versus Canada naman po, na kailangan may mga it's reiterated na to require the applicant provide corroborating evidence that they would experience discrimination. While there is a split in the jurisprudence on this, 𝐂𝐴𝐻 versus Canada, to reiterate, it is an error for an officer to limit their assessment of hardship in applicant's home country to hardship connected to a personal characteristics. This error confuses the criteria applicable to an agency application under subsection 25-1 of 𝓪𝐵𝑟𝑝A with those that define a person in need of protection under subsection 95-1 of 𝓪𝐵𝑟𝑝A. So, yun ho yung mga batas na pwede natin gamitin kung tayo po ay mag-a-apply ng agency application. Siyempre po, ito po ay mahabang proseso ng pag-apply. Minsan po inaabutan ng 1.5 year, yung iba inaabutan ng 3 years. Kaya po sa ating pagsulat sa ating immigration officer, kailangan napaka-importante na i-cite natin ang lahat ng reason kung bakit kailangan bigyan kayo ng permanent residence dito at bigyan kayo ng exemption. Anyway, ako po bilang immigration consultant, gumagawa po ako ng agency applications. At kung interesado po kayo, sulatan nyo lang po ako sa aking email na nakalagay dito sa YouTube at sasagutin ko po kayo within 24 hours. Maraming salamat po, mag-iingat po kayo at mabuhay po tayong lahat.